Still remember the way the wine glass caught the light when my boyfriend's father set it down too hard on the table. Not enough to break anything, just enough to make a sound. Everyone heard it, nobody said anything. And that was the moment I realized this dinner was going to be exactly what I had prepared myself for, and somehow still nothing like what I expected. His name is Owen. My boyfriend. We've been together for 3 years, and I want to be clear about something before I explain the rest. He is a genuinely good man. Patient, self-aware, the kind of person who remembers small things. He remembered that I don't like cilantro after one dinner in month 2. He drove 40 minutes in the rain to bring me soup when I had a cold the following winter, even though I told him not to. I say this not to paint a picture of some perfect relationship, because that would be dishonest, but because you need to understand that when I tell you about his father, it is not a story about Owen. Owen knew exactly who I was. He had known for the better part of 2 years. His father had no idea. That part wasn't Owen's fault either, not really. His parents retired to Scottsdale about 18 months before Owen and I got serious. His father, Franklin, had spent 32 years as a commercial litigation attorney, the kind who argued cases involving nine-figure settlements, who had a framed Wall Street Journal profile on the wall of his home office, who used the phrase, "in my experience," the way other people use punctuation. His mother, Catherine, was warmer. She called Owen every Sunday morning and asked about his week, and sent us a box of Omaha steaks at Christmas with a handwritten note tucked inside that said she hoped we were eating well. Franklin and I had spoken on the phone twice, briefly. The kind of calls where you say all the right things and learn almost nothing about each other. So when Owen said his parents were flying in for a long weekend and he wanted me to finally have dinner with them, a real dinner, not a 40-minute lunch, I said yes without hesitating. 3 years in, this was the right thing to do. I wanted to meet them. I was a little nervous, the way you're always a little nervous, but I was not dreading it. I should explain what I do. I'm a federal public defender. I've been practicing for 8 years. 6 months ago, I was appointed to lead the office here, head of the federal public defender's office for this district. I'm 33. I know that reads young for that position, and I won't pretend the appointment didn't raise a few eyebrows, including from people who wished me well. But I had tried 41 federal cases, won a significant majority of them, and when the previous head retired, the selection committee made their decision. It wasn't a gift. I had earned it in the way that anything worth having requires you to give more of yourself than feels reasonable for longer than feels fair. I don't lead with this information in social situations. Not because I'm ashamed of it, I'm proud of it, but because I've learned that titles have a way of changing how people talk to you before they've decided if they actually like you. I'd rather someone form an opinion of me first. The job can come up naturally, or it doesn't come up at all. At dinner it came up. We met at a restaurant in the city, one of those places that feels expensive without trying too hard. White linen tablecloths, wine list organized by region, bread that arrived warm without you asking. Catherine was already at the table when Owen and I walked in, and she stood up immediately and hugged me like she'd been looking forward to it. Franklin stood too, firm handshake, direct eye contact, the practiced courtesy of someone who had spent decades making first impressions in conference rooms. We ordered drinks. There was small talk. The flight, the weather in Scottsdale, how the city had changed since Franklin and Catherine used to visit when Owen was in law school here. Franklin had gone to law school himself at Georgetown, class of 1981. He had tried cases in federal court throughout the 80s and 90s before transitioning to a large firm. He mentioned the cases the way people mention old photographs, with fondness and just enough detail to signal that the details could go much deeper if invited. I asked questions. I was genuinely curious. 32 years of federal litigation is a career worth asking about. For the first hour, everything was fine. More than fine. Catherine was easy to talk to. She asked about my family, my work in broad terms, how Owen and I had met. I told her we met through mutual friends at a going-away party for someone neither of us had known very well. She laughed at that. Owen added that I had spent most of the party near the food table, which is true and not something I'm embarrassed about. Franklin was more reserved but engaged. He asked about my background, my law school where I had clerked. When I mentioned I had clerked for a federal district judge after graduation, he nodded in the way that signals approval without quite saying it. Then someone, I think it was Catherine, innocently asked what I was working on these days. And I gave the same answer I usually give in social settings, that I work in federal criminal defense, that I represent clients who are facing charges in the federal system, that it keeps me busy. Franklin set his wine glass down. That's important work, he said. Public defenders in particular, chronically underfunded, chronically overworked. I always felt for those attorneys when I was on the other side. The other side. He had been a litigator at a private firm. I understood what he meant. It can be a difficult system to navigate, I said. The federal system especially, he said. I spent years in it. It's not forgiving. He said it with the ease of someone recounting something they knew better than most. The sentencing guidelines alone, most defense attorneys don't really understand how to work with them effectively. They accept the framework instead of challenging the underlying assumptions. I nodded. I took a small sip of water. The thing about federal defense, he continued, is that you really need someone who has spent years understanding the procedural landscape. It's not intuitive. Mandatory minimums, the way charging decisions get made at the DOJ level. It takes a long time to develop real instinct for it. Owen caught my eye across the table. A small, careful look. Not alarmed, but attentive. Makes sense, I said. I watched a lot of public defenders over the years, Franklin said. Good intentions, genuinely, but they were always playing catch-up. The caseloads are impossible. You can't do meaningful work when you're managing 120 clients. He wasn't wrong about the caseloads. That's a real problem, a structural one I'd been working to address for 6 months. But something about the framing had started to settle under my skin, the certainty of it. The way he was explaining the federal system to me as though I were a student who had just asked a clarifying question. Catherine asked about the bread, whether we should order more. Owen said yes, probably. Franklin kept going. The best thing that ever happened to the federal defense bar, he said, was the Booker decision. 2005. Before that, the guidelines were mandatory. No flexibility. Booker opened the door for real advocacy at sentencing. Most people who haven't practiced in that era don't fully appreciate what that shift meant. I knew what United States v. Booker meant. I had written a 70-page brief on sentencing disparity that cited Booker in its opening paragraph. I had argued in front of 3 different circuit court judges about the downstream implications of that decision. I had trained the attorneys in my office on how to use it. I picked up my fork and started on the salad that had arrived at some point during this. What does your office handle? Catherine asked me, gently redirecting. Federal cases across the district, I said. Drug offenses, fraud, firearms, immigration-related charges, a range. Do you enjoy it? She asked. I do. I find it meaningful, in a way that's hard to describe without sounding like a brochure. She laughed softly. Owen smiled. Franklin had not finished. The immigration cases especially, he said. That's become such a complicated space. The interplay between federal criminal prosecution and civil immigration consequences. Most attorneys conflate them. They don't understand that a guilty plea in a federal criminal case can trigger entirely separate immigration proceedings that no one in the criminal case has jurisdiction over. He was describing something called the intersection of Padilla obligations and collateral consequences. It is something I think about regularly. It is something I have spoken about at continuing legal education conferences. That's a real issue, I said. It trips up a lot of defense attorneys, he said. The ones who don't have deep federal experience especially. It's one of those areas where good intentions really aren't enough. I looked at him, not with hostility, just looked at him for a moment with the full awareness of what was happening and the calm, unhurried certainty that I would not say anything about it yet. Owen was watching me. He knew. The main course came. Salmon for Catherine, A ribeye for Franklin. Owen had the duck. I had ordered the halibut, which arrived beautifully plated with something involving roasted fennel that I would not be able to fully taste because I was using approximately 30% of my attention on staying composed and the remaining 70% on whatever Franklin was saying next. The one thing I'll say, Franklin continued, somewhere in the middle of his steak, is that the system is difficult to reform from the inside. The people who go into public defense, they're idealistic, which is admirable. But idealism without strategy is just frustration with good intentions. You need people who understand how the system was actually built, not how it should work in theory. I put down my fork, not dramatically. I set it down beside my plate the way you do when you've decided to say something and want both hands to be at rest before you do. I run the office, I said. Franklin looked at me. The Federal Public Defender's Office, I said. I'm the head. I've been in federal criminal defense for 8 years. I tried my first federal case 2 years out of law school, and 6 months ago I was appointed to lead the district office. The attorney who had the position before me retired after 24 years. The table was quiet, not the uncomfortable silence of something broken, the quieter kind, the kind where something has been recalibrated. Franklin's expression moved through something. I watched it happen in real time, and I want to be fair about what I saw because it mattered. It wasn't defensive. It wasn't immediately embarrassed in the kind of way that makes people double down. It was something more like genuinely surprised, and then something behind that, something slower that looked like recognition. I didn't know that, he said. I know, I said. I tend not to lead with it. Catherine had her hand over her mouth. Not to hide distress. She looked like she was trying not to smile. Owen said very quietly, I probably should have mentioned it earlier. Probably, I agreed. And I wasn't angry with him, even though I could have been. I understood why he hadn't. He had wanted his father to form an impression of me before the resume arrived. I'd thought the same thing myself, once. And it had not gone quite the way either of us planned. Franklin was quiet for a moment. Then he said something I was not prepared for. Tell me about the sentencing work. The disparity stuff. Not as a challenge. Not with the tone of someone trying to recover footing. With what sounded like actual curiosity. Like a person who had just realized the conversation he thought he was having was, in fact, a different conversation, and who found that interesting rather than threatening. So I told him about the research we'd done on geographic disparity in federal sentencing outcomes, how defendants in different districts receive substantially different sentences for identical conduct under the same guidelines, and how we'd use that data to build mitigation arguments. I told him about a case I'd handled the previous year involving a first-time nonviolent offender, facing a mandatory minimum that the judge herself had said on the record she found excessive, and how we had argued down to the low end through a combination of Booker advocacy and a forensic psychologist's report that took me 3 months to find funding for. I told him about the brief and the circuit court argument and what happened. He asked questions, good ones, the kind that come from someone who actually knows the terrain and is locating you on it. At some point, Catherine refilled her own wine glass and leaned back in her chair with the quiet satisfaction of someone watching two people find out they actually have something to say to each other. We stayed at the table until the restaurant started clearing adjacent tables. I had the kind of conversation I usually only have with colleagues. Specific, pointed, occasionally disagreeing about procedural strategy, with the pleasure that comes from disagreement between people who are arguing in good faith. Somewhere in the middle of all of it, Franklin said, without making a production of it, I owe you an apology for the beginning of the evening. I made a lot of assumptions. It's all right, I said. It's not, really, he said. I spent 40 minutes explaining your own field to you. That's not something I'd do with anyone I'd given fair credit to. I thought about that for a second. I appreciate you saying that. I don't say things I don't mean, he said. Catherine will confirm. He really doesn't, she said pleasantly. We left the restaurant around 10:30. Owen and I walked to the car, and neither of us said anything for the first 2 blocks. It was a cool night for the season, the kind where you can feel the edge of the air without being cold, and the city was quieter than it usually is. Streetlights and a few people walking dogs. I should have told him, Owen said. Yes, I said. I don't know what I thought. I wanted him to like you first, not the title. I know, I said, and I get that, but he was lecturing me for 40 minutes. I know. A pause. Are you angry? I thought about it honestly. Not angry, I said. I was, a little, in the middle, but he handled it well, better than a lot of people would have. He liked you, Owen said. He texted me from the bathroom, said you knew your stuff. I looked over at him. He texted you from the bathroom. He does that. He texted me from the bathroom at my law school graduation, too. I don't ask anymore. I laughed. The kind that comes from somewhere real, not the polite kind. There's something I've been thinking about since that night. Something I've turned over a few times and don't have a clean conclusion about. Franklin was not a bad person. He was a person who had spent 32 years being one of the most knowledgeable people in any room he walked into, who had built a career on authority and precision, and the kind of confidence that gets case verdicts, and who walked into dinner with his son's girlfriend and slotted her into a category without asking first. I've done that too. Not in exactly the same way, but I've made assumptions. I've talked to a witness on the stand and underestimated what they understood and found out 10 minutes later I was wrong. I've started a sentence with "what you need to understand is," and then had someone gently clarify that they understood it already. It doesn't make it comfortable, but it makes it human. What I think about, actually, is the moment after I said it. I run the office, and the way Franklin's face moved. Because he could have gotten defensive. He could have qualified everything retroactively, found a way to make what he'd said technically accurate so the ground could shift back underneath him. A lot of people do that. It's easier. He didn't. He just recalibrated. Genuinely and without ceremony, the way you adjust course when you realize the map was slightly wrong, not because someone forced you to, but because accuracy matters more to you than being right. That's actually harder than it sounds. A few weeks later, Franklin sent me an article about a Ninth Circuit ruling on sentencing enhancement challenges. Just forwarded it with 3 words: thought of you. No explanation, no context. The kind of message that assumes you'll know what it means without being told. I did know. I wrote back, good case. We're watching it closely. He wrote back 4 hours later, figured. Owen told me that was the most enthusiastic his father had been about anyone he'd ever dated. I told Owen that was either very encouraging or mildly concerning. And he said probably both. And I said yes, probably both. I still think about that dinner sometimes. Not with frustration, the way I might have expected to. More with something I can only describe as a quiet kind of satisfaction. Not the sharp, quick kind that comes from a public correction, not the kind you'd want to record and replay, the kind that sits with you longer, the kind that comes from having been in a room where someone looked at you, assumed they had the full picture, and then found out they didn't, and then, more importantly, decided to actually look. That's rarer than it should be, and I'll take it. I thought a lot about why that dinner stayed with me the way it did. Not because it was dramatic. It wasn't. Not really. Nobody raised their voice. Nobody stormed off. The salmon was good, the wine was decent, and by 10 o'clock we were all laughing. But something about it kept coming back to me in the weeks after. The way certain experiences do when they've quietly rearranged something in how you see the world. Franklin is not a villain in this story. I want to be clear about that. He's a man who spent 3 decades being genuinely good at something difficult, who built a reputation that held weight in rooms I would have been nervous to walk into 10 years ago. That kind of career shapes you. It gives you confidence, and sometimes confidence has a way of outrunning the information it's based on. What I keep coming back to is the choice he made in the moment after I told him. Because that moment, the one right after you find out you've been wrong, is a test of character that almost nobody prepares for. We all practice being right. We practice being confident, being persuasive, being the person in the room who knows the most. Nobody really practices the other thing. Nobody rehearses what it feels like to realize you've been explaining the ocean to a marine biologist. Franklin passed that test. He didn't deflect, he didn't qualify, he didn't perform a kind of false humility that's really just embarrassment wearing a costume. He just stopped, recalibrated, and started listening. And what came after that was one of the better legal conversations I've had outside of a courthouse. There's something in that worth sitting with. Not about him specifically, but about what it takes to do what he did. Because the instinct, when you've been caught making assumptions, is to protect yourself. To explain why the assumption was reasonable. To find the technicality. And that instinct is not weakness exactly. It's just human, the nervous system doing what it does when it senses exposure. But to people who override it, who choose accuracy over ego even when it's uncomfortable, those are the people you end up respecting. Those are the people you want in your corner when the stakes are actually real. I've been underestimated before, plenty of times. Some of those experiences left me with a cold, tight kind of anger that I carried longer than it deserved. This one didn't. And I think the difference was what happened after, not the correction itself, the response to it. Franklin's willingness to look at me differently once he had better information was not a small thing. It was, in its quiet way, a form of integrity. I think about the 8 years that went into that dinner, the cases, the late nights, the arguments I lost before I learned how to win them, the moments where I didn't know if I was good enough and kept going anyway. None of that was visible when Franklin looked across the table at me. He saw what he expected to see. That's not a crime, but it's a reminder, for me as much as anyone, that the picture we form of someone in the first 5 minutes is almost never the whole picture, and the willingness to revise it is one of the quieter forms of courage there is. Owen asked me on the walk back to the car whether I was angry. I told him the truth, not really, not anymore, because somewhere between the entree and the moment Franklin forwarded me that Ninth Circuit ruling with 3 words and no explanation, I realized we had skipped straight past a bad first impression and landed somewhere more honest. That's not nothing. That's actually a lot.